The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain how an estate is divided in the absence of a will. So first let's talk about some terminology. If someone dies without a will, that's called dying intestate. And therefore the state's intestacy laws apply of the estate that they resided in when they passed away. They only apply to the probate estate. This is property that's outside of a trust or outside of accounts with a designated payable on death beneficiary. Intestacy laws vary based on the state, and more than one state's laws can apply if the person resided in one state and owned real estate or other significant property in another. The Illinois state intestacy laws are as follows. If the person is survived by a spouse and descendants, half goes to the spouse, half goes to the descendants. If the person is survived by a spouse and no descendants, then the spouse gets everything. If the person is survived by the descendants and no spouse, then the descendants get everything. And when I say the descendants get everything, this is divided per stirpes. This is a term that means basically on each level, generational level, each person in that level gets a share. If one of the people in that generational level is deceased and they have children, then their share is split among their children, and it goes all the way down the line, however many levels are involved. So if there's three children involved, one of the children has passed away, but that person has had two kids, so there's two grandkids of the deceased child, then child 1 who's alive is going to get a 1/3 share, child 2 who is alive is going to get a 1/3 share, and the grandchildren of deceased child number 3 are each going to get a 1/6 share, so they're going to split that 1/3 share among them. That's how per stirpes works, and that flows throughout this whole conversation. So anyway, we talked about if the descendants survive the person but no spouse, the descendants receive basically everything per stirpes. If the person is not survived by descendants or a spouse and only survived by parents and or siblings, then the estate is divided equally among the parents and siblings, except that if one of the parents is deceased, then the surviving parent gets a double share. If there is no spouse, no parents, no siblings, no descendants, basically no direct immediate family, then the maternal and paternal sides of the family split the inheritance. So you kind of go up the chain to the mother and father's families, and they split the inheritance according to these same intestacy laws we discussed. If the deceased person is not survived by anyone, then the state of Illinois gets everything. Important thing to remember is that the deceased person's debts have to be paid off first before this even comes into play. So this only deals with property that is around after paying off all of the deceased person's debts. Let's talk a little bit briefly about how trusts and payable on death accounts work. So one of the main estate planning strategies that people use is a revocable living trust, and this often is used in place of a will or along with a will. And a trust is basically a legal document, but it is also an entity that can own property separate and apart from the person who created it. So any property that's owned in the trust will go directly to the beneficiaries of the trust. The trust will specify, just like a will, who's going to inherit what. So even if the person didn't have a will, but they have a trust, any assets that are in the trust are going to go to the beneficiaries listed in that trust. Same with payable on death accounts. If the person didn't have a will, but they have a retirement account that specifies who's going to inherit the assets in the retirement account, or a life insurance policy that specifies who the death benefit is going to, even if the person didn't have a will, those things go directly to the people specified on the payable on death account. Finally, let's talk about who's in charge of this operation. Who's going to be the person in charge of distributing the assets? It's easy when there's a will. The person who wrote the will name an executor, and that's the person who's in charge of distributing the assets. If there is no will, then usually a close family member will petition the court to be named as administrator of the estate. If all of the family members agree on who the administrator is going to be, then the court will name that person as the administrator. If there's a disagreement among the family members as who is going to administer the estate, then there will be an argument about it in court, and the court will decide who is going to be named as the administrator of the estate and responsible for distributing the estate according to these intestacy laws that we discussed. Thanks so much for listening. If you have any questions, please leave them in our comments section on our website, learn-about-law.com, or on the comments section to our YouTube video if you're watching this on YouTube. Please subscribe to our YouTube, iTunes, and SoundCloud stations, and feel free to give us a call for an initial consultation at 630-324-6666. Thanks so much.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.